Good Saturday morning to everybody. Excited to have a cup of coffee and talk about what we all want to talk about on a Saturday morning, which is Medicaid and nursing home care and things like that. So again, just some expectations, very informal here. This is not a lecture. We are going to do a lot of talking, but if you have questions, put them into the chat or the Q&A portion of this Zoom. What we've learned through this pandemic is that Zoom is actually pretty cool. It allows us to connect with people in a different way and a little bit easier so that you don't have to come downtown to talk to us or anything like that. So we intend to do this today. And again, to talk about, how we protect assets. We're going to unravel some myths about Medicaid, things that everybody has probably heard from a neighbor or read online that maybe are not so true. And then how to plan for these things when they come up, nursing home care and things like that. And we're going to do this every month. And so if you learn some things today that you think that your neighbor or your loved one might benefit from, get them connected with us to log on next month when we do the same thing. We're going to kind of do the same talk every month, just to talk about these basic concepts. And so nothing earth-shattering in here, but again, we're just wanting to get together on a Saturday morning with some coffee and talk about some of these things that affect everyone's lives, basically. So
I was just going to add that, the point of this talk about this conversation is, number one, Medicaid is not as scary as people think it is. And number two, we do this every day. So we can help people navigate the world of Medicaid. And let's just talk about this and let's get started.
Right. Okay, so the first thing, we talk about protecting assets. I think that there's maybe a little misnomer that Medicaid is not for me, or I'm never going to really need to worry about that because Medicaid is for people that have nothing. And that's really one of the biggest myths that I see. I mean, most of our clients, most of the people that we deal with are not millionaires. They're not by any stretch. They're just people like you and me. I mean, they have their 401k, they have their house, they have their income, their retirement, they're just good people. And when we're talking about planning for Medicaid and protecting assets, you don't need to be a millionaire in order to engage in some of this planning. And so, everybody's sort of, I think, heard of the 5-year look back period. And everybody says, well, is this going to turn into 7 years or 10 years? And I don't think it is. It's 5 years. And what that really means is while you're healthy, maybe as you enter into retirement or, a few years into retirement, you start to look at what can I put away now to save in case me or my spouse goes into a nursing home. And basically it's while you're healthy, why don't we take a look at maybe transferring your house or a savings account that you have set aside and transferring that into an irrevocable trust. And when you do that, when you're healthy, when everything seems to be okay, unforeseen circumstances notwithstanding, you put an asset like your house or maybe some savings or some assets into an irrevocable trust, and then life goes on. And as long as, nothing happens where you don't need to enter into a nursing home within 5 years of making that transfer, then those assets are totally protected from ever needing to be taken into account when you're applying for Medicaid or going into a nursing home or something like that. And so, again, very basically, let's say you're 70 years old and you're thinking, me and my spouse, we're both relatively healthy, everything's going okay, but I really am kind of concerned that if something happens and we go to a nursing home, that we're going to have to sell the house. We're going to have to, spend down all of our assets. At that point in time, why don't we consider moving your house into an irrevocable trust? and moving a bit of assets into an irrevocable trust. And then again, life goes on. Something happens 6-7 years down the road where you or your spouse goes into a nursing home. You don't even need to disclose that transfer. They're going to ask, have you transferred anything in the last 5 years? And the answer is going to be no. And your house and whatever else you put in there is completely protected. And so it seems complicated when we talk about it with people, and you hear maybe some stories from neighbors, or you read something on the internet that this type of planning is very, very sophisticated. It is, but that's our job to do that. The basic strategy is, while everything is okay, consider making a transfer into an irrevocable trust. And again, life goes on for a period of 5, 10, maybe nothing ever happens, but you're assured that those things are protected.
Yeah, the irrevocable trust, you have most likely a child in charge of that trust as a trustee. You would still be able to live in your house. If you transfer the house to the trust, you would be a tenant of that house. So nothing changes. Legally, the ownership of the house is transferred to the trust, but nothing changes with your day-to-day life. The same thing with your assets. So, everything in that trust would be protected for you for Medicaid. And if you would ever need that money back later, we work with your child and your trustee to get that money back. So although you're relinquishing ownership of that asset, that's why we have a trusted child, or whoever is the trustee in charge, so we can make that change later on.
Yeah.
So the planning technique that a lot of people use is the caretaker child exception. And this is written right in the rules, in the regulations, that if someone needs that level of care that a nursing home provides, where they need help with their activities of daily living, and a child is able to move into the house 2 years prior to entering the nursing home or facility, whatever that may be, the house actually can be transferred penalty free straight to that child during the Medicaid process, during the application. So there's a lot of paperwork involved with this. You have to get a doctor's opinion that yes, this person needs nursing home level of care. The child needs to take notes and time, like a timesheet of what he or she has done during that month. And that way, your Medicaid is saying, well, yeah, he moved in there, but is he really doing any work for mom or dad? So you need that documentation to prove that. The other option with that caretaker exception, along with the house, is, well, you can also have a caregiver agreement in place where that child gets paid. So you are protecting your mom and dad's money and assets from going to the nursing home. Well, you're paying your children to care for you instead. So that's what the care contract is in place. And instead of being paid monthly, maybe that child just puts a mortgage on that house. So there's a lot of things involved with the caretaker child exception. You get to protect the house, you get to get money on a monthly basis, or maybe even a mortgage on that house. And that's just one way of protecting that money from going to the nursing home.
Yeah, and my comment would be that this caretaker child exception is in the federal Medicaid law. And a lot of times, I think clients think that these planning techniques are something that maybe were created by us scheming elder law attorneys, and that's just not the case. There's very strong public policy behind this caretaker child exception to the transfer of the house, and that is everyone wants people to live at home in the community for as long as possible. And what this exception to the transfer rules is basically promoting is that if a child is going to move into the house and make sure that mom or dad can stay at home in the community and not in a nursing home, at least for 2 years, then they deserve and they're allowed to take title to the home without a penalty. And that's a good public policy. So this isn't a trick. This isn't a scheme or anything else like that. And the hard thing is you have to plan ahead of time. So it's important for people to know about this, not when mom or dad gets sick, but maybe if mom or dad gets sick, that they know about this and it's an option for people. It's an option for maybe, again, a son or a daughter to move into the house. And so, if, people come to us sometimes and they're like, well, I've been taking care of my mom or dad for 3 years. And the question is, well, have you lived there? Have you gone through these steps? And they're like, well, if I would have known that, then I would have done this. I would have documented all of this so that I could get the house transferred to me.
Documentation is the key.
Right.
I mean, I've had that so many times where the client, the child comes in and says that they've lived in the house for 3 or 5 years with mom, and we've been taking care of them. Well, Medicaid, Job and Family Services, Medicaid doesn't care about that unless you have the documentation, and they are all for this rule, but there's no proof for them. So, I mean, you have to be proactive in your planning. Right. So, having that conversation with the child now, goes a long way in case, mom or dad needs that care.
Right. And knowing this information now is why we're doing doing this talk, actually.
Mm-hmm.
Okay. Another sort of, strategy that, again, is sort of sanctioned in the Federal Medicaid Act is gifting within the look-back period. So we do intentional gifting a lot in order to protect people's assets. So generally, an individual can gift roughly half of their assets, depending on their income and the cost of care. And then immediately apply for Medicaid. The other half of the assets that the individual has is usually put into either a pooled trust or put into a Medicaid compliant annuity, which will pay them income to pay for their care during the penalty period. So getting back to basics, if you make a gift and then apply for Medicaid, they're going to penalize you for that. It's called an improper transfer. Improper transfer is a scary word to people because it sounds like you've done something wrong. But if you do it with a purpose and you know that, let's say you give $50,000 away and that's going to cause a penalty period of, 8 or 9 months, then you take the other amount of money that you have in order to spend that down essentially and qualify for Medicaid, and you put it into an exempt pooled trust. And then you apply for Medicaid. You tell the Department of Job and Family Services, look, we made a gift. We know that that's going to create a penalty period of 8 or 9 months or whatever it is. And they say, okay, they impose the penalty. And during that penalty period, you're using the money out of the pooled trust to pay for your nursing home care. After that penalty period is up, Medicaid starts paying the nursing home, and you've been able to save $50,000 or whatever it is. And again, the biggest point I want to relate it to everybody listening and continually, and you can tell your neighbors and friends and loved ones, this type of planning is not just for rich people. It's not just for millionaires and things like that. We help so many people that have, again, all that they have may be a house and $100,000 at the point where someone's going into a nursing home. And when we're able to save the house and we're able to save up to half of those assets for their loved ones, a life's work of everything, that is so important to people. And again, so you don't have to be rich. You don't have to be, wealthy in order to think about protecting what you have. And, we have clients that are wealthy. We have clients that aren't wealthy, but everybody's the same when it comes to paying a nursing home and qualifying for Medicaid.
Yeah. And then, that look back, or excuse me, the gifting within the look back period, it's an improper transfer. I just want to make this clear. It's called an improper transfer. It doesn't mean that it's an illegal transfer.
Right.
The rules state that, hey, if you gift during the 5 years, then we'll penalize you. It doesn't say if you gift, you're never going to get Medicaid. It just says we'll penalize you. So we use the rules here to protect the assets, to protect as much as we can. And that gifting within the 5-year period, that's an intentional gift. So I always tell clients, if they would meet with me, I tell clients, don't be making, willy-nilly gifts here. We want to do an intentional gift. So we'll guide you of what to do, but just don't go the next day gifting $50,000 to your child. That's happened before. Or they purchase a car, and it messes up the plan. So we have to work together in order to formulate this plan. All right.
Yeah, and to Ethan's point, you have to do this with intention. You have to do it with the knowledge of the rules, and that's where, again, we come in. And so the purpose of this talk is to get the kind of word out that you can do some of these things, but you have to do it with intention. You have to do it within the rules. And again, these aren't tricks. This isn't a scheme. These are the rules that the federal government has put in place and set out to all the states, and the states put in their Medicaid plans, and we're operating within those rules.
So the next, technique that clients use is when they have a disabled adult child. And a disabled adult child is defined generally, is that child receiving some sort of Social Security disability, either SSDI or SSI? That's the easiest way to prove to Job and Family Services that the adult child is disabled. If you do have a disabled adult child, a transfer to that child is penalty free. The rules state you could transfer $1 million to this disabled adult child, and you can get on Medicaid that day. So that's, you don't hear those rules too often that greatly benefit the Medicaid applicant. But this is one of the good rules in there, because, a disabled adult child, the parents want to make sure that child is being taken care of after they pass away. And what better way than to be able to set aside money penalty free and be able to be on Medicaid. A lot of disabled adult children can't handle their own money, and that's okay, because you can transfer it to a special kind of trust. It's called a sole benefit trust. So it's designed for that sole benefit of that disabled adult child. That disabled adult child doesn't have to be in charge of that trust. It can be another child, another relative, another close family friend. There is no Medicaid payback provision in that trust, either at your death or at your disabled adult child's death. So you can dictate where that money goes to after you're on Medicaid, after your adult disabled child goes. You can dictate where that, if it goes to a charity, if it goes to your other children, your other grandchildren, and so forth. So this is a great rule. A lot of people don't know it, but it's out there if you have a disabled adult child. And we use this if you want to gift to, if you have a disabled adult child and just, a typical child. We use this as part of our, gifting technique to lessen the penalty period if you do want to gift to your, typical child. Mm-hmm. So this is a great rule. Do you have anything you want to?
Yeah, I mean, again, it gets back to the public policy of it. This is not, and I'll say it again, this isn't a trick that us elder law attorneys have come up with. This exception to the transfer rule was put into the Medicaid Act for a reason, and that is that an individual with with an adult or with a disabled child can use their money to benefit the disabled child and then qualify for Medicaid. It's not an improper transfer. And that's obviously for a reason. That was put in there for a reason. And so it's difficult to describe it as an opportunity, but when an individual needs nursing home care and they have an adult or a disabled child, someone on Social Security disability or SSI, they can transfer all of their assets to that person or to a trust for that person, and then apply for Medicaid the next day, get it without penalty. It's there for a reason.
One more point to that, the rule is also if you have a minor child, you can also gift to that minor child. Obviously, that doesn't come up as often because if you need nursing home care, you're more elderly and you don't have a minor child. But I've had a client that is in his 50s and had a traumatic brain injury, and he did have a minor child. So we did gift to that minor child the same way as we would to an adult disabled child, and saved him all of his money. Right. So keep that in mind too.
The other, I think maybe misnomer about Medicaid is that you have to be completely poor in order to qualify for it. And, prior to, I would say 1988, the Medicaid system was basically set up that you did have to basically divest yourself of all of your assets before Medicaid would pay. But what they found during that time was that the spouse that didn't need nursing home care would end up being completely destitute, living in the community. And a lot of times that spouse, whether they needed it or not, would follow their ill spouse into the nursing home, and Medicaid would be paying for two people. And so they put in the Medicaid Act these spousal impoverishment protections so that the community spouse does not have to be completely destitute while their other spouse is in the nursing home and needs Medicaid. And so basically what this means is if you're a married couple and one of you needs nursing home care, the community spouse is allowed to keep the home. That means that we transfer title to the community spouse of the home. They're allowed to keep their car. They're allowed to keep up to $128,000, a little more than that, of cash assets. And there's a minimum, there's a maximum, and that can be calculated. That's a little more complicated. But you're allowed to keep cash. And then the community spouse is allowed to keep all the income that we could possibly generate. And so a lot of times we'll take the 128,000 that they're allowed to keep, we'll transfer the home to the community spouse, the car, obviously, and some other things. And all the other money that we would ordinarily need to spend down and put, maybe paying the nursing home until those were spent down, we can buy an annuity, a Medicaid compliant annuity for the community spouse that will pay them increased income for the rest of their life. And so at the end of the day, we're looking at the community spouse being able to keep the home, $128,000 or so, and have the benefit of turning all the other assets into an income stream for them. And the institutionalized spouse is on Medicaid, they get Medicaid paid for, and all the marital property, everything that the couple came to the table with is benefiting the community spouse one way or another. And that's something that I think a lot of people misunderstand about the Medicaid process and what the law is there to do. And that is to, again, protect the community spouse.
One thing that you should take from this, one important thing that you need to take from this is everything that if you have a married couple applying for Medicaid, one spouse applying for Medicaid, virtually everything can be protected for that community spouse. Virtually everything. Yep. A lot of people think that that's not the case, but the rules are there to protect that community spouse, and it's a great tool. A lot of people just don't know it, right. But you need to keep that in the back of your head throughout this. For a married couple, everything can be protected for that community spouse.
And a quick story. I mean, I just dealt with a married couple. The wife went into the nursing home, and the people at the nursing home said, okay, everything's good. When you're out of money, we'll help you apply for Medicaid. They, and it's not the nursing home's fault, but they never ever, told the clients that there were these spousal protections in place, or anything like that. They eventually came to us, and when we told them, no, you don't have to spend everything down. The community spouse, the husband in this case, is allowed to keep $128,000. We can transfer the house to this individual, and we're going to take everything else, and we're going to increase his income for the rest of his life. And they said, well, the nursing home said we had to spend everything down. These are the sort of myths that we're here to bust. That everybody should know that these protections are in place, and they're in place for a reason. Again, this isn't a trick.
Right. The nursing home, the Medicaid liaison at the nursing home, or the business manager at the nursing home, they know of Medicaid, but they don't know, the Medicaid law to a T like we do. They're not lawyers. So, I mean, like Dave said, we're here to unravel the myths here. One huge myth is that, we hear all the time that a client says, I must sign my house over to the nursing home in order for me to get on Medicaid. This is after I had a client come in and said they had $500,000 they entered in the nursing home, plus a house. He came in and he spent down to over $100,000. He only has like $100,000 left in his house. And he said, I only have a few more months before I can get on Medicaid. And I said, no, you can get on Medicaid now. You can gift this money, this $100,000 or a portion of it, and get on Medicaid now. He said, well, what about the house? I think I have to sign that house over to the nursing home. No, the house is exempt. It's exempt for the community spouse. This individual is single, but it's exempt for a single individual as well. If they sign a letter of intent to return home, even though their intent may not be to return home, this is a farce in the Medicaid rules that, we have listservs talking about this all the time in our attorney world, that, this is stupid that the clients have to do this, but all they have to do is sign a simple statement that they have the intent to return home. That house is exempt. But if you still own this house as a single applicant for Medicaid, and you pass away still owning this house, there is a mechanism in Ohio law where Medicaid can put a lien on this house and get some of their money back that they've given you. This is called Medicaid estate recovery. So this is an individual on Medicaid owning assets at death. Medicaid can try to get some of the money that they've paid that individual while they were on Medicaid. So when we do our planning, whether a single individual or community spouse, for a community spouse, we say, okay, the house is exempt for the community spouse. For a single individual, we take into account the home as part of the assets. Even though it's exempt, we take into account this asset because of estate recovery. So, as part of the gifting plan, we might gift the house, or we might have to sell the house and to collect the money because of Medicaid estate recovery. Medicaid estate recovery, let's just say that Medicaid has given an individual $500,000 in Medicaid benefits. The house is only worth $100,000. Well, if that person still owns the house and they pass away, Medicaid can put a $500,000 lien on that house, kind of like a mortgage. So if their child wants to sell the house, they have to pay Medicaid. And if it only generates $100,000, Medicaid will accept that $100,000 and just, call it a day and walk away. But you just gave Medicaid $100,000 where we could have planned before, applying for Medicaid with that house. So Medicaid estate recovery is always something that you have to think about. You can't own assets while on Medicaid because Medicaid can get those assets back.
Right. Another sort of myth is something I mentioned before, which is I have to spend all my money before I apply for Medicaid. And as we've discussed before, that's just not the case. The law is set up again so that the community spouse is not going to be made to be destitute. They're allowed to keep the house. They're allowed to keep this community spouse resource allowance of $128,640. That's a maximum. Again, there's a lot of calculations that go into that. They're allowed to keep their income, even for a single individual. Again, people aren't aware that there are opportunities to preserve assets by making intentional planned gifts and dealing with the penalty period on purpose. I think it's really scary for people to think about protecting assets because it's an improper transfer, and everybody's heard all of the sort of horror stories, and they know somebody that, oh, well, this person gave away assets and, tried to apply for Medicaid and they penalized them and everything else like that. We do this every day on purpose. And so what I would say to everybody listening is don't be afraid to engage in thinking about Medicaid as something that is there for you, and in utilizing the Medicaid Act and the planning process to do the things that the federal government has said are okay. Again, to use the law. People do tax planning all the time, right? I mean, you should not be expected to pay more taxes than you actually owe. And so when you do financial planning, this is the same thing. We're talking about, taking advantage of a federal program to pay for your nursing home only after you qualify. And how do you qualify? Well, it's not just by spending your assets down. I mean, that's one way to look at it, but engaging.
The federal government doesn't want you to spend your assets down like that. They want you to, invest in your children and in the economy. That's what the federal government wants you to do. They don't want you to become destitute and your spouse to become destitute,
Right.
One big planning technique that we use is with IRAs. A huge myth is that you have to, use your IRA to pay for your spouse's nursing home care. Obviously that's a huge myth. The example that we provided here is, and we see this all the time. A lot of clients' biggest assets are their house and their IRA, or 401k, whatever retirement plan that they have. So the IRA can be rolled over to a Medicaid compliant annuity for the benefit of that community spouse. And so they receive an income stream from this Medicaid compliant annuity for as long as their life expectancy is. And those are based on Medicaid tables that Medicaid already has provided. It has nothing to do with health of that community spouse or, their family history. It's, black and white, their age. So in this example, they have a $450,000 IRA. If you roll that over to a Medicaid compliant annuity, that is an exempt transfer for Medicaid purposes. And it's also a non-taxable event because you are converting it to another qualified plan. Once you start receiving that monthly payment, though, is when you start having to pay the taxes. the income taxes on that IRA. But we use that as part of our planning, so we know that it's coming. So you can stretch that out, 5 years, 10 years, 15 years. It all depends on what your needs are, and what the amount is. It all depends on a case by case basis. But this IRA is obviously protected along with all these other assets that you have, especially for a community spouse.
And in this example, where John and Sue are married and they have $125,000 a house, and a $450,000 IRA. If you look at the end result of this, Sue qualifies for Medicaid. And what comes before that? John is able to keep everything that they had when they came to the table. It's just structured in a different way. He keeps his home, he keeps the car, he keeps the $125,000 in cash investments, and his IRA that was a $450,000 is converted to an income stream, which is benefiting him in the end. And a lot of people just don't understand that this is the way that the Medicaid Act was designed, to help the community spouse be as healthy, happy, and live in the community for as long as possible while taking care of the individual that needs nursing home care. Okay. Another sort of myth that we hear all the time: everything I own is countable for Medicaid purposes. I got to sell all the stuff that I have in my house, my bedroom set, my TVs, and everything else like that. It's a total myth. We've talked about this before, but the home is an exempt asset, one way or another. Your car is an exempt asset. Prepaid burial contracts, funeral contracts are exempt. The community spouse resource allowance, that up to $128,000 or so, that's an exempt asset. They're not going to count that against the spouse that needs Medicaid. All the stuff in your house, tangible personal property, there's no inventory. They're not counting those things. Now, if it's, gold Krugerrands or something like that hidden under the floorboards, something that has actual value that you could convert to cash and pay for your nursing home, that's different. But the stuff in your house is not countable for Medicaid. And so a lot of times, instead of spending down to the nursing home in order to qualify for Medicaid, we will invest in these exempt assets, like putting a new roof on the home, buying new appliances, making improvements, paying off debt on the home. Again, investing in these exempt assets is a far better way to qualify for Medicaid than just paying $10,000 a month to the nursing home.
One thing clients like to do is purchase a new car. If they have a huge account, like bank account, that they haven't touched in a long time, it's just sitting there, and they're driving, a junker car, they finally say, okay, maybe I can buy a new car here, and that a car of any value is exempt. So, I wouldn't get too crazy and buy a $75,000 car like one client of mine did. But, maybe this is a time where you can invest in, a new car. So there are a lot of options out here for, exempt assets.
Or the community spouse, the spouse that's going to remain in the house. Instead of paying the nursing home off every month, pay the mortgage off. And what that does is it eliminates a monthly payment that the community spouse would have otherwise. And what does that do? That essentially raises your monthly income, because you're not making this mortgage payment every month. And, after paying off debt and, investing in exempt assets and putting aside the community spouse resource allowance, again, everything that we're doing is to benefit the community spouse. And then the spouse that's in the nursing home gets the care that they deserve, obviously, and you qualify for Medicaid. One of the other things that we haven't mentioned quite yet, and maybe we will, in the next slides, but I'll say it now, is when you transfer the house and that cash and everything to the community spouse and qualify for Medicaid for the spouse that's in the nursing home, after that takes place, the community spouse can do whatever they want with those assets. They can win the lottery the next day and become a millionaire, and that is never going to be expected to go to the spouse in the nursing home. Medicaid will pay for those those costs. And we can do planning techniques to avoid estate recovery at all costs, Medicaid coming back. So.
Yeah, essentially at the Medicaid application, at the date of the application, Medicaid sees the spouse's assets and finances as divorced.
Mm-hmm.
So community spouse has their assets, the institutionalized spouse has her assets.
Mm-hmm.
So I talked about this a little bit ago, the estate recovery, but a lot of people say this, if I still own the house, the state of Ohio, and I die and I'm on Medicaid, the state of Ohio will take my house. That is, a half truth. They won't take the house. The state of Ohio is not in the foreclosure business. They're not going to foreclose on the house. They will put a lien on that house. So they will take the equity from that house. But, we avoid this at all possible. We don't want, the Medicaid applicant to have ownership of any assets, including the home, when they pass away. If it does happen, in the rare circumstance where the Medicaid recipient does own the house and they pass away and they were on Medicaid, the state of Ohio will put a lien on that house. The house is transferred to the child. The child can live in that house, mortgage free. They can rent that house. But until they sell that house, that's when Medicaid gets involved. Medicaid wants their share of what they've received. But we, as part of our planning, we avoid that completely. So.
Yeah, and a lot of times, if there's a Medicaid lien on the house, it gives obviously children, the recipients of that house after their parent dies, a lot of anxiety. Oh my gosh, there's a lien on the house. Are they going to foreclose? And the answer is no. You have to deal with that lien if it exists when you sell the house. Out of the proceeds that you're going to, those are going to go back to the state to the extent of Medicaid benefits provided. But there's also an opportunity to have a negotiation with the Ohio Attorney General's office. I mean, a lot of times we'll go to the Attorney General's office for estate recovery and say, we're never going to sell this house. Will you remove the lien, in exchange for $15,000 or something like that? And a lot of times they'll say, okay, we'll take that. We'll release the claim. We'll take off the lien because we realize that it's either $15,000 now or nothing 100 years from now or something like that. There's always a little bit of room for negotiation. And I guess my comment on this is, don't be afraid of this. And again, we can plan ahead to avoid it, but if it exists, there are ways to deal with this without being afraid.
Right.
Okay, now we get into, again, some things that we've already talked about, but in a little more detail. And this is what we can do now, planning for long-term care. And that doesn't mean that you're in a crisis. That means that you're here listening to us on a Saturday morning. What can you do now? This 5-year gifting plan is something I think I started off this talk with. And the example is relatively simple. John and Sue, they're 70 years old. They're in relatively good health. They have substantial assets. This 1.2 million example is on the high end. You can, cut that. You can take a tenth of this, and the principle still applies. But the point for John and Sue here is they establish an irrevocable trust. They transfer about $700,000 in it as a gift to their children. They think, no matter what happens, I just want to make sure that this amount of money, whatever they decide, is going to be there for their kids. In this example, 8 years later, Sue goes into a nursing home. They have about $500,000 left, and the house and the car. John keeps $128,000 of that. He annuitizes the remainder, giving him additional income for the rest of his life. And Sue qualifies for Medicaid. And at the end of the day, what we've accomplished here for John and Sue is $700,000 is completely saved for their kids. John is able to keep the house, the car, $128,000 in cash, and all the income that he's able to receive from annuitizing the remainder. And Sue is taken care of for the rest of her life in the nursing home.
So once again, we talked about this before, but I just want to reiterate that, the spousal annuity is key for a married couple applying for Medicaid. It's our main technique that we use for crisis planning, where one spouse needs nursing home level of care. I want to point out, though, we say nursing home level of care. That applies also to, it's called Passport. That's where it's a Medicaid waiver where Medicaid services can be received in the home, where you have caregivers coming into the home and Medicaid covers those costs. So the same rules apply for Medicaid, where you're financially, you have to, get your assets to a certain level. But I just wanted to point out that nursing home level of care means nursing home or care in the home, covered by Medicaid. So in any event, we use spousal annuities for both of those avenues, nursing home or care in the home. It's so, theoretically, it's so simple that you convert money, IRA, cash, for the benefit of the community spouse, and this community spouse just gets an income stream, and you save virtually all the money for the community spouse. It's, I love the way that the Medicaid rules use this income stream for the benefit of the community spouse.
Yeah, and the thing is, there are catches to this. The Medicaid compliant annuity has a lot of, it's not an annuity that you would purchase if you were doing financial planning. You would only purchase a Medicaid compliant annuity if you were trying to apply for Medicaid for your spouse or something like that.
It's definitely not an investment tool.
Yeah, and it's not an estate planning tool either, but it is a permissible way to use a couple's assets to benefit the community spouse so that they can, again, live as healthy, happy, and as long as possible in the community while their spouse gets the care that they need and deserve. Another tool that we use all the time, and again, this is just, everything ties in together. This is a complex web, and we're trying to make it simple. But again, we talked about it before, the caretaker child exception, and a lot of times we use these care contracts in order to benefit, in order to lawfully compensate children for taking care of their parents. And again, the policy behind this, the reason why this is permissible is because Medicaid, the government, the state, the federal government, they do not want people to go into nursing homes when they could otherwise stay at home. And so in this example, Sue probably needs to go to a nursing home because she needs 24/7 oversight, and she needs assistance moving around with meals. She needs help with bathing, with medications and things like that. But she's not declining cognitively, and she doesn't want to go to a nursing home. Who does? Pam, Sue's daughter, is willing to provide the care that Sue needs to remain in the home. Maybe she's not willing to completely move in and qualify for this caretaker child exception, but she's willing to do things to make sure that Sue can stay in the community. And so they enter into a care contract that Ethan or I draw up. We pay Pam about $16 an hour or so, obviously less than a third party, a separate care provider would be paid. That's basically been sanctioned by the Ohio Supreme Court that you're allowed to pay family members, but there ought to be some consideration given to the fact that a lot of this compensation is diminished by the fact that you're taking care of mom or dad, love and support. And in this case, if Sue doesn't have the cash to pay Pam, we can put a mortgage on the home so that, again, if Sue eventually is on Medicaid or on Medicaid and then passes away with the home in her name, and Medicaid puts a lien on that, we have Pam that has a first lien on the home, and she can be paid back out of the proceeds of the sale of the home before Medicaid gets paid back. So I don't want to get too complicated here because, you know, our time is running short, and obviously this is more complicated than what we're talking about. But I'm here to tell you that there are opportunities in every situation to benefit the individual, benefit the family, and also, you know,
Keep them at home.
Keep them at home, which is,
Yeah.
again, the policy. That's a reason why things are permissible.
So this is, I love this planning technique when it comes up, because there's a windfall for the family. So in this scenario, you have a single applicant that needs nursing home level of care. He's got, you know, a house worth $150,000, and that's what the auditor's value is, the county auditor. So that's the first value that Medicaid uses, is the auditor's value. And, you know, typically the auditor values property less than what the fair market value will use. So in this case, he's got a $150,000 auditor's value home, and about $125,000 in investments, cash, CDs, a small IRA, let's say. So he gifts, as part of his technique here, the gifting technique, he gifts the home to his children. The $125,000 is put into a pooled trust to pay for that penalty period as a result of gifting that house. The $125,000 is spent on his care for the next 21 months. At the end of that 21 months, he qualifies for Medicaid, and Medicaid begins paying his nursing home bill. In the meantime, the kids sell the home then for $200,000. They just made a, you know, $50,000, or John just made a $50,000 extra gift that, you know, Medicaid doesn't care about. You know, all they care about is the auditor's value. You know, I love seeing this, you know, just benefit the family here when something like this happens. And so it's not going to happen every time. It depends on what the value of this home is, but I see it more often than not, you know, because the auditor's value is often less than what the actual value is.
Right. All right, so we're going to end with talking about the Medicaid application process. And again, one of the most confusing and I think misunderstood parts of Medicaid is, how do you apply? When do you apply? What do you need to do to apply? And, you know, look, the application process for Medicaid is probably worse than an IRS audit. I've never been through one myself, but what our clients typically tell us after we've gone through the Medicaid application process, when it's all over, when we're able to make the phone call and say, your case was approved, I told you it would, but, you know, I know it's been a long process, 3, 4, 5, 6 months sometimes after you apply for Medicaid that it's finally approved. They say to us, I don't know how anybody goes through this process without hiring a lawyer like you guys. I don't know how anybody can possibly do this without your help. And so I just wanted to talk about the basic process. You apply for Medicaid in the month that you become eligible, and not before and not after. So all the planning that we do is geared towards, when do we need to apply? And we're not going to apply until we know that we're eligible. There's a long list of documents that are needed: your ID, your health insurance cards, your social security card, the verification checklists are extensive, and it takes a lot of work for individuals to get those documents together. Current financial statements have to be supplied to the agency to show that that your finances are eligible, right? But they're also going to ask for 3, 4, 5, 6 months of statements going backwards. And then they're going to look at those statements at how you spent your money. And if they see that there was a $5,000 check written out on, 3 months ago, they're going to ask what that was for to make sure that wasn't an improper transfer. If it was, we're prepared to talk about it and say why, that happened and how we're going to deal with it. But again, they're going to ask a lot of questions.
Yeah, that will bring up, if they see something, that looks fishy to them, they'll say, okay, we need at least 5 years worth of all statements now, because that's what they can do. That's what that 5-year look back period is designed for. They want to look at any improper transfers during that 5-year period. All counties are so backlogged with Medicaid applications. They have been only asking for a few months worth, but if they see something that's a red flag to them, they can ask for 60-month worth of statements. So we would be prepared for that if that ever comes up, but keep that in mind when you're collecting all the statements.
And my last point about the Medicaid application process itself is, if you apply in the month of October, you may not get approval until January or February even, particularly in these times. But that approval goes back to October 1st. It's retroactive, or it's valid for the month that you applied. And that's another thing that a lot of people, I think, misunderstand about the Medicaid application process. But what I would say to everybody involved is, do not trust nursing homes to guide you through the Medicaid application process. And I don't mean this because they're bad people or they have the wrong intentions or things like that, but they're not invested in you. You need to get this Medicaid application approved. And if you make a mistake, if you apply in October for Medicaid and you're not going to get a decision until January, February of next year, and you made a mistake way back in October, what happens during that October, November, December, January?
You're on the hook.
You're on the hook to the nursing home. So that's how critically important it is to get it right the first time, and utilize folks like us who know what we're doing when we're talking to caseworkers to shepherd this application through the process. And I've seen way too many cases where individuals are applying on their own. They're smart, sophisticated people. They're applying for mom or dad, and they get a denial 4 or 5 months down the road, and there's no going back. You can't cure something that happened 4 or 5 months ago.
Right. In this last slide, I should preface this with, Dave and I are pretty conservative when we do our Medicaid applications. What I mean by that is we are pretty certain that you should get an approval of Medicaid. And that's because we don't do anything risky. We make sure that the assets are to a certain level, and we're doing the plans that have worked in the past for a multitude of other clients. If there is a risky maneuver, we're obviously going to tell you. We're going to tell you this might not get approved. If it doesn't get approved, then you have certain levels of appeal that you have to go through. Or if the county just makes a terrible decision that, why are you doing this? We have to appeal this. This is the appeal levels that you have to go through. It's first is the Bureau of State Hearings. You just have a phone hearing in front of a hearing officer with the county. You can further appeal to the administrative appeal level, which is just a written appeal. You just have a brief that the attorney or you files. And even rarer, if you still don't have a good decision, you go to the Court of Common Pleas at the county level, the trial court level. I've only in a handful of times have ever been to administrative appeal level. I've never been to the Court of Common Pleas. Have you, Dave?
I have a number of times in my early career, but
when you did more risky stuff with
with my boss. The point I'd like to make about this is that the appeal process takes months, and sometimes if you're going to Common Pleas, it takes years. What do you think is happening during that time? The nursing home is billing. And so I don't want my clients I don't want to apply for Medicaid and think that we're going to need to go to a state hearing.
Right.
Because win or lose, and I know we can win at a state hearing, but win or lose, the anxiety that goes on during those months where mom or dad or spouse is in a nursing home and Medicaid isn't approved yet.
And you see a bill with tens of thousands of dollars that's owed to their nursing home. I mean, that's...
And so the point of this is that I don't want any of my clients to have to go to a state hearing. And when Ethan said that we're relatively conservative, we follow the law. We won't apply for you until we are absolutely certain that you're eligible. And then we're going to make sure that the caseworker knows that you're eligible. And when they come back with weird questions and things like that are confusing, and a lot of times they're confusing to us, we're the ones that are going to go back to them and say, no, community spouse is allowed to keep this money. They're allowed to keep the house. They're allowed to keep the car. They're allowed to keep all their income. And the institutionalized spouse is qualified for Medicaid. We get that approval, and then life goes on. And we don't ever want to get to this process. But again, we're the ones that are doing this. And how could anybody be expected to do that without sort of the knowledge that we bring to the table? So that's the talk, and I'm going to stop sharing. I think we have a bunch of questions, and we'll try to maybe field some of those. Let's see. Okay, so all right, so we'll try to just go. There's not too many of them. The first one here. If I make my daughter the trustee of my irrevocable trust, she controls it, then we have a falling out and she hates my guts. Can she keep the money and never give me any assets?
Great question. Yeah.
It is a great question. What if she's the trustee, we're on good terms, but she gets a divorce? Can her husband go after the assets? That's a really great question. So a lot of times when we do irrevocable trust for asset protection and 5-year gifting plans, what I typically want to do is name 2 co-trustees, at least, 2 trustees. So that, and they have to act in accordance with each other. There's no individual actions. So you have 2 people that have to agree in order to do what they need to do. Naming a trustee is one of the most difficult parts of estate planning, whether we're talking about special needs estate planning, normal estate planning, or elder law estate planning. Picking your trustees is really important. Another thing you could do is you could add something called a trust protector or a trust advisor that has sort of a veto power and a replacement power over a trustee. So there's a lot of protections that we can build into this irrevocable trust to ease some of those concerns.
Right.
And the question about the husband or the spouse, no, a spouse cannot invade a trust or they really have no right to any sort of an inheritance or anything else like that.
Right. The ownership is under the trust name and not the daughter's name in that scenario. So if the daughter gets a divorce or bankrupt or gets sued in a car accident, in a liability case, those assets are protected for that trust. So for the family, it's not going to be invaded in that scenario.
So the next question is, does this work if the house is owned by both spouses? Does joint ownership create a difficulty? Well, I think that the answer to that is if one of the spouses applies for and qualifies for Medicaid, the community spouse, we're going to transfer the title to the house into the community spouse's name solely. Okay, so that asset is completely separated from the Medicaid recipient. And then we can engage in planning to avoid any sort of estate recovery or Medicaid implications for that community spouse. And so it's very important to think about how the house is titled, particularly when you're going through a Medicaid application process. And that's something that we do with all of our married Medicaid applicants, is make sure that the house is eventually transferred into the community spouse's name alone.
So the next question is, when we gift to a disabled child, a disabled adult child, is there a chance the child will lose benefits? It depends on what benefits that disabled adult child is on. If that disabled adult child is on Medicaid and SSI or SSI, then yes, it would jeopardize that child's benefits, but we would put it into that sole benefit trust to protect that child's benefits. So, we would put those, luckily, we are a Medicaid, an elder law firm, and we're also a special needs firm. So we have the correct tools to, save that money for and protect that money for that disabled adult child.
Okay, so the next question is kind of specific, but it's about an individual that has two daughters, but they're high functioning with special needs, no SSI or waiver, but some services from the board of the DD board. Is there another way to protect assets? Well, I don't know how to specifically answer this, except for, again, if there is a child that has a disability recognized by Social Security, then a mom, a dad, or anybody can protect their assets by, again, placing those into a sole benefit trust for the benefit of a disabled person. Again, it's an opportunity, it's a planning opportunity for an individual, but we're always concerned about really two people's Medicaid eligibility, right? The individual that may need the care, but then the recipient of those gifts. And that's where this sole benefit trust comes in place. It's a type of a special needs trust. It doesn't have the state recovery. That's a specific question, and we'd be happy to have a talk about that.
I should just point out, the easiest way to prove that a child is disabled is that child is receiving Social Security. There's other ways to prove that disability. So it's a case-by-case basis. All right, so this is a great question. What happens to funds in a Medicaid compliant annuity if the owner dies before the annuity period ends? So the owner, so in this scenario, the institutionalized spouse is on Medicaid and the community spouse is receiving an annuity. So it's a Medicaid compliant annuity for very specific reasons. The reasons why it's exempt from Medicaid is the state of Ohio is the next recipient of that Medicaid compliant annuity when that community spouse passes away. So this is a rare scenario. So where the community spouse would pass away before the institutionalized spouse. If that does occur, though, Medicaid will only receive whatever benefits that they have given the institutionalized spouse. So let's make a scenario here, okay? So you have a $300,000 Medicaid compliant annuity that's been paying out monthly to this community spouse. It's let's just say it's a 5-year term, okay? Community spouse passes away in year 3, and there's still $50,000 left in this annuity, all right? Medicaid has given $500,000 to, or no, let's just say $100,000 to institutionalized spouse during those 3 years, all right? Yes, Medicaid will take that $50,000 from that Medicaid compliant annuity, but you just saved $450,000. So yes, there are drawbacks to the Medicaid compliant annuity, but that's a rare circumstance where the community spouse will pass away before the institutionalized spouse.
Yeah, and it gets back to the whole point of it. It's not a investment strategy. It's not really even an estate planning strategy. It's a tool to use to make sure that the community spouse is able to benefit with increased income so that they can live healthy and happy in the community as long as possible. If they were to pass away, then it's a Medicaid compliant annuity for a reason. It's going to go back to the state, or it's going to go to the institutionalized spouse, which to pay the nursing home care so that Medicaid pays less. So it's not an estate planning tool. It's not a sheltering assets tool. It's a tool to make sure that the community spouse is taken care of. All right, so then the next one is, what do you mean community spouse, community assets? We have a revocable trust. Is it necessary to convert it to an irrevocable trust to take advantages of the protection you mentioned? Quite simply, no. You do not need, I mean, you can, again, intentionally create an irrevocable trust, but Medicaid looks at the couple's assets, however they're titled, as assets belonging to the person applying.
They see through a revocable trust.
Right. And so, but you can take advantage of these these spousal impoverishment protections, the community spouse resource allowance, the cash you're allowed to keep, the house, the income, all the things that we've talked about. You can do that whether there's a revocable trust, whoever's name the asset is in. We can work through that process. But again, the point of this talk is it would be nearly impossible to do that on your own. We can help you navigate through that process.
So the next question is whole life insurance or term, an untouchable pocket of money. So I'll answer that question first. A whole life policy is a countable asset for Medicaid. That means that there is a cash value in 99% of whole life insurance policies. There is a cash value to it. That cash value is the countable asset. Term is not a countable asset because there's no cash value. Most group insurance policies that you get from an employer, that's a non-countable asset too, because there's no cash value to that. So insurance is always the toughest asset to deal with in the Medicaid process because there's a cash value to it. We have to account for it. We might have to liquidate that insurance policy to get this person qualified. So the next question here, should this Medicaid compliant annuity be acquired during good health or as an emergency pursuit? It's always the crisis emergency pursuit. You never should do this Medicaid compliant annuity while you're healthy.
Okay, so this question is, I worked through this for my parents in Ohio before they passed. I've since moved out of state. What resources available to refer me to a firm like yours in a neighboring state? Give me a call, shoot us an email. We'll refer you to a certified elder law attorney in the state and in the area that you're in. We work with people like us nationwide. We're very well connected. Janet Lauder in particular is known nationwide. We know a lot of elder law attorneys, and we'll connect you with someone that can help you out. And then finally, this is a good question. What should a family do who are aging themselves, income reduces, as well as the sole benefit trust runs out? What are available resources and options for the care of a disabled adult? There's no way to answer that question that is satisfactory. The biggest fear of our clients who have children with disabilities is how in the world are they going to how is life going to go on for them when we're not around? You can only do what you can do. You can name your trustees, you can name your trust advisors, you can name your beneficiary advocates, you can put a plan in place, but no one's going to do what you do. No one's going to take care of your child the way that you have for your entire life. And so the answer is not to ignore it. The answer is to engage in the planning process and to put some things in place. But these are difficult decisions. Now, during this pandemic, these sort of things are at the forefront of everyone's minds as we all think about what's going on in the world, our own mortality, everything that's going on in the world. Everybody's thinking about this more and more. And I wish I had a great answer for everybody, but that's the point of this conversation, is to kind of talk about it, come to terms with what's available, what you can do now in order to have a little peace of mind.
Anita, I see your question here. We'd be happy to speak to, your group that you want us to speak to. I mean, that's exactly what we're here for, is to help. So we can absolutely give options to people and let them know that, Medicaid isn't as scary as people think. And Melissa, who should the planning be with? Can you be a little bit more specific on that? You mean like with the parent or with the child?
Well, I want to encourage everybody to, reach out to us, set up a telephone call or a conference or a meeting.
Okay.
If you have specific questions.
Can you hear me?
Yeah.
Oh, okay. Yeah, I'm sorry. It was in reference to my question about when you're aging, your income reduces, and options for care of the disabled adult who's a sibling. I was just wondering, who should the planning be with? I think it was mentioned that there should be some planning done. I'm just not sure who that's with. I don't know if that's solely with the attorneys or if there's other people. For instance, he's hooked in with the County Board of Developmental Disabilities and has other, like medical care set up. But I just wondered, was there someone else I should plan with? Like if I passed away tomorrow, I guess is what I'm saying.
I think you start with a firm like ours, with lawyers that do what we do. We have a care coordinator on our staff. Her name is Janelle Leonard. She's a licensed social worker. She helps bring another level of planning to, what we do, sort of a boots on the ground approach. We engage with the county boards of developmental disabilities. We engage with service providers, again, outside social workers. It's really an all of the above approach. And the more people that you can engage with and not just do specific planning, but general conversation, a letter of intent is really important to kind of get your story out so that if you're gone tomorrow, that you have enough people that you've engaged with that can pick up and understand who you were and what needs to be done to take care of your loved one. And that's all I can tell you, is just to be proactive, to engage, and to utilize the expertise of people that do what they do in their areas. You can't do everything on your own. You obviously all know that. But that's why we're here having this conversation this morning. So
thank you.
All right. Well, listen, I appreciate everybody's attention over the last hour and 20 minutes. And again, we intend to do this on a monthly basis. Every talk's going to be slightly different. And we're going to, again, come to the table here, have a cup of coffee and have these general conversations. So if you know anybody that has some questions that would benefit from having a conversation like this, please spread the word. And we're always here as a resource. If you have any questions specifically, please give us a call. Ethan and I are always willing to talk. So thank you very much.